Good morning. Welcome again. And Representative Norris, please move your bill. We will wait for the A5 amendment as it's coming down right now, so we will get started.
Great. Thank you, Chair Noor and members of the committee. Like so many Minnesotans, I am furious about fraud. And it's why I introduced this bill last year to beef up the Medicaid Fraud Control Unit. This bill has bipartisan support, and it passed out of the House last year. Unfortunately, it got stuck in the other body. So we're back today with an updated bill, hoping to get it passed into law to meet the moment for Minnesotans. Medical assistance fraud steals from hardworking taxpayers across Minnesota. It also steals money meant to provide health care to low-income Minnesotans. That's disgraceful, and we're here to crack down on that type of fraud. This bill does what Minnesotans expect us to do: enhance our ability to investigate fraud and stiffen penalties for those who steal from government programs. The bill, as amended, would add 18 new staff members, including 11 new investigators and 3 attorneys, to the unit to match the growth in Medicaid spending and fraud claims. It also expands the definition of Medicaid fraud to keep up with our evolving understanding of the schemes to defraud the government as part of the business model of fraud. It establishes new tiers of penalties for medical assistance fraud over $100,000 and $1 million. It brings medical assistance fraud prison time in line with other theft laws. It allows us to better prosecute long-running and sprawling fraud schemes by adjusting the statute of limitations and including medical assistance fraud in the state racketeering law. And lastly, we expand the Attorney General's subpoena authority so it can get access to the same financial records that county attorneys are able to access. This office is already doing meaningful work. The Medicaid Fraud Control Unit from 2019 to 2025 secured over $80 million in civil penalties and criminal restitution. And compared to Medicaid fraud units in similarly sized states, Minnesota has won the most convictions. Importantly, members, in tough budget times, there is a 3-to-1 match from the federal government for the state dollars that we contribute to the Medicaid Fraud Control Unit. So this is a good, responsible use of state dollars to fight fraud. Simply put, this bill supports the work of catching people who steal from medical assistance and make sure that they are held accountable. Thank you, Chair Noor.
Thank you so much, Representative Norris. And since we don't have the amendment, I just wanted to make sure that you move your bill. Representative Norris moves House File 2354 to be re-referred to Judiciary, Finance, Civil Law Committee. So with that, we'd like to welcome Attorney General Ellison. Welcome, and please introduce yourself and proceed with testimony.
Certainly a pleasure to be with you, Chairman Noor, Chair Schumacher, and all members. Thank you very much. I'm pleased to be joined by Representative Norris and also Nicholas Wonka, who is the director of the Medicaid Fraud Control Unit in my office. He is the hands-on, on-the-ground one who leads a group of prosecutors and investigators who do this work every single day, and I hope you'll entertain some of his thoughts as well. So when people commit Medicaid fraud, they're stealing from the most vulnerable neighbors, they're stealing from honest care providers, and they're stealing from the government. It is the job of my office and the federal government to hold Medicaid fraudsters accountable. Across the country, AG offices house what are called Medicaid fraud control units. Every state has one, and they are in part funded by the federal government and by state governments. Now, even though we're not the exception among the states in having control units, we are exceptional in having one of the most effective units in the country. Since I was sworn in as AG of the state of Minnesota, we've won more than 300 convictions in Medicaid fraud and won more than $80 million in judgments and restitution for Minnesota taxpayers. This is a highly specialized team of people who are good at what they do. So good that the federal government itself has recognized that our MFCU, Mafuku is what we call it, has won more convictions than any other state with a comparable Medicaid budget. So while we're proud of the work, we don't want to rest on our laurels. Last year, excuse me, wow. Oh, yeah. Last year, I was proud to partner with Matt Norris and Senator Ann Johnson to introduce the Bipartisan Medical Assistance Protection Act, or MAP Act, to provide more resources and tools for fighting Medicaid fraud. This year, we're amending the bill to add even more resources and add more tools to fight Medicaid fraud, because the moment we're in calls for us to do more. First, let me review the additional resources we're asking for. The MAP Act adds 18 dedicated specialized staff to our Medicaid Fraud Control Unit, bringing the total number of staff from 32 to 50. It's very important to make clear that the federal government matches every dollar we dedicate to fighting Medicaid fraud on a 3-to-1 basis. For every dollar Minnesota puts in, the feds put in 3. So 18 new staff might sound like a lot, but Minnesota only needs to pay a quarter of that. Buy one, get 3 free. This means that we can add 18 additional fraud-fighting staff for only $1.2 million per year. Here's why this is important. When the unit's staffing level was last set at 32, Minnesota's total Medicaid budget was about $13 billion. Now it's $20 billion, and that's more than 50% higher, yet our staff is what it was. The referrals that the unit receives from state agencies and managed care organizations are on track to triple this year over the last year. The recommendation for 18 staffs comes directly from the Federal Department of Health and Human Services. In their last analysis of the unit, they recommended that we reach the staffing level by 2028. Yes, we know it's 2026, but the level of staffing will help us meet Minnesotans' expectations now. And as you know, the State Director of Program Integrity, Tim O'Malley, recommended just 2 days ago, maybe 3 days ago now, that the fraud-fighting resources be expanded to our office. Now, I'd like to talk about some of the improved legal tools that we're asking for, and Mr. Wonka will elaborate a little bit. The MAP Act 2.0 will close some legal loopholes that have allowed some fraudsters to avoid accountability. Right now, Minnesota law defines Medicaid fraud as presenting a false claim for reimbursement with intent to defraud. That's it. Such a narrow definition is challenging for prosecutors because it does not capture all of the morally repugnant and criminal conduct that can be part of Medicaid fraud. The MAP Act updates the definition of Medicaid fraud to clearly ban things like lying with the intent to defraud while enrolling as a false provider, falsifying records about delivery of services, or destroying records when you receive a request for those records from a state agency. These things, I believe, are now illegal and constitute Medicaid fraud, but there have been courts who have raised questions. A more improved definition will put these convictions on more solid ground. The MAP Act will equalize penalties for fraud. And when I say equalize, I just mean equalize. They won't make them more severe than other types of fraud. They'll equalize them. They'll bring them up too, so that it won't be more advantageous to steal from the government than a private sector party. Right now, if you defraud Medicaid of $36 million, you're subject to the same penalty as if you defrauded it for $36,000. This is because of a law that hasn't been updated in decades. And our bill creates new penalties for Medicaid fraud over $100,000 and over $1 million. And yes, we do have claims that high. Right now, Medicaid fraud is attractive for scammers because the current penalties for stealing from a private entity are higher than stealing from the government, and we should all fix that. The MAP Act adds more legal tools to help investigate and prosecute major fraud schemes, like adding Medicaid fraud to our racketeering laws, giving our office the ability to subpoena financial records that we now have to go through a county attorney for, and expanding a statute of limitations so that we can better go after long-term fraud schemes conducted over years. The role of the Attorney General's office in fighting Medicaid fraud is investigating and prosecuting individuals when state agencies or managed care organizations refer their cases to us. We're not on the front end. We're on the back end. The front end is screening and is screening the good and the bad providers or whoever. The middle slot is monitoring people. We are at the point where the 911 call is made, and we then determine probable cause and then charge the case and prosecute it if it exists. So let me just say, members, it would be great to have bipartisan support on this very important bill, and we thank you for your questions. And I humbly ask the chair for time for Mr. Wonka to present.
Dr. Wonka.
Yes. Chair Noor, Chair Schomacher, members of the committee, thank you for the introduction, Attorney General. I'm Nick Wonka. I'm the Director of the Medicaid Fraud Control Unit, and I'd like to just elaborate on a couple points that the Attorney General made. First, I'd like to add more context for our request for higher staffing. In 2019, when we went up to 32 full-time staff, we had 144 unique referrals that year from DHS, from law enforcement, from the public. We've been well over 200 referrals in each of the past few years. This is a more than 40% increase in referrals with no additional people to take on the work. And the cases that we're getting are only more complex. They often now contain networks of providers or owners of multiple agencies who are all separately defrauding the Medicaid program. And we need to investigate and prosecute people for each and every one of those instances. These cases take many more resources to investigate. A healthcare agency with hundreds of employees, hundreds of clients, is a lot more investigative resources than a single home care worker who's defrauding the program, as you can imagine. And as Attorney General Ellison noted, referrals this year are up dramatically. Just to put a finer point on it, last federal fiscal year, we got 218 separate referrals. This federal fiscal year started on October 1st of 2025, so we're a little over 4 months in. We are already over 200 referrals from DHS, from managed care organizations, from the public, from other law enforcement entities. But that increased work hasn't stopped us from getting results. Even though Minnesota's Medicaid fraud unit does not have a top 10 staff size, we're in the middle of all states. We punch above our weight. Last year, we ranked 6th in investigations per Medicaid expenditure, 5th in fraud charges, and 8th in fraud convictions in the entire country. Further, we're on average 5th in fraud convictions in the entire country over the last 6 years. That's a long-running track record of success for our unit when compared to other states. I'd also like to provide a little more context on the policy changes we're asking for. Now, an important reason we're asking to amend the medical assistance fraud statute to cover current gaps in it is because district courts read the statute inconsistently. Some courts read it expansively to include the fraudulent conduct that law does not specifically name, some of the things that the Attorney General touched on. But some other courts have dismissed cases of ours because the conduct we allege did not match up word for word with either the theft by false representation statute or the theft by swindle statute or the medical assistance fraud statute. Amending the law in the way that we are asking for here to name many different types of fraudulent behavior we are uncovering in our investigations should fix this inconsistency and allow for more uniform justice throughout the state. And as Attorney General Ellison mentioned, we are also asking for subpoena power that county attorneys already have when they conduct criminal investigations. The revision would allow us to subpoena financial records in provider fraud investigations, which we do, and are conducted under Minnesota Statute 256B12. County attorneys have the authority to do this when they're investigating welfare fraud, so fraud for recipients who are inflating their income, their resources, or something like that to obtain benefits. We ask for the same authority when we conduct provider and fraud investigations. In giving us this authority to subpoena these bank records that county attorneys can is consistent with ensuring accountability for all fraudsters throughout the state of Minnesota, no matter what programs they're stealing from. So that's the bulk of our request, and we'd ask that you give us the funding for more people and the statutes that enhance our ability to investigate and prosecute so that we as a state can hold people accountable for these crimes. Thank you.
Thank you so much for your testimony. We do have the A5 amendment, and I wanted to ask the nonpartisan staff, Mr. Johnson, to walk us through the A5 amendments. Representative Norris moves the A5 amendment. Please help us understand what is in A5 amendment.
Chair, members, Ben Johnson with House Research. Senate room. Mr. Chair and members, Ben Johnson from House Research. I'm going to walk through the A5 amendment. This is a lengthy amendment, but it is a page and line amendment, so if I don't mention a section, it is staying the same as the underlying bill. The first section change that you'll see is Section 2. This is a technical change. This particular section of law was amended last session. There's no substantive change to the underlying bill. It just updates the existing statute to the 2025 version. Section 3 is the new provision that the Attorney General and Mr. Wonka just explained in detail. Briefly, the first subdivision identifies the various ways in which someone can now commit Medicaid fraud under this particular bill. It identifies 8 different potential scenarios that would qualify as the crime. Subdivision 2, which is on page 2, starting at line 29, establishes the penalties. It establishes a base penalty for a violation that would have a maximum prison sentence of 10 years. And then it has enhanced penalties. If the theft is over $100,000 but less than $1 million, the maximum period of imprisonment would become 20 years. And then in paragraph C at the top of page 3, if the theft involves over $1 million, the maximum period of imprisonment becomes 30 years. Subdivision 3 is a new penalty. This is a gross misdemeanor penalty for failing to keep or maintain records that you're required to keep under the other areas of law related to the human services. Those are in Chapter 256B and 245A. Subdivision 4 on page 3 identifies that this is a continuing offense. This is related to the statute of limitations. Typically, a statute of limitations begins to run once a crime has been completed. This just indicates that if there's a series of actions that constitute Medicaid fraud, you don't start from the first of those. The offense is considered continuing, and so the statute does not begin to run until those are all complete, or if it's ongoing, it has not yet begun to run. So this allows a longer look-back period for older offenses that may come to the attention of law enforcement or the Attorney General's office if there's an ongoing pattern of this conduct. Subdivision 5 is a venue provision. This just indicates that there are multiple places where this could be brought and charged depending on the underlying facts of the case. Subdivision 6, which is at page 3, line 22, creates a restitution provision. This is an expansion of the typical restitution authority in law. This would allow the collection of restitution for certain offenses that were committed but not necessarily charged as part of the underlying charges in the case. That's the end of the updates to the bulk of the section. The rest of the amendment is largely technical, so at a high level, you'll see a change to Section 5. This is similar to the earlier change. This particular section of law was amended last session. There's no substantive change to the underlying bill. It's just updated to reflect the 2025 version. The same thing is true of Section 6, which is on page 425. No substantive change to the underlying bill, just this particular section was amended last year. Finally, Mr. Chair, the change at page 6, line 9 is to the appropriation. The underlying bill had an appropriation of $390,750. This updates to reflect the numbers that the Attorney General referenced earlier, which would be $1,230,000. I've had some questions about the changes to the base. Just as a reminder, this is an appropriation in the second year of the biennium, which means this would be an ongoing appropriation and be in the base. Mr. Chair, that's all the walkthrough of the amendment.
Thank you so much, Mr. Johnson, for the explanation of the A5 amendment. Any member discussion on the A5? Seeing none, all those in favor, please say aye.
Aye.
Opposed? Abstentions? Hearing none, the A5 is now adopted. To your bill as amended, Representative Norris. Do you have any updates or you want to go to member discussion? Members, we have the bill before us as amended, and we will stick to the bill before us. So please, if you have any questions, make sure that it's based on the bill which is in front of us as amended. Representative Barker.
Thank you, members. First concern that I would have with this is we've seen, judges dismiss cases with fraud, okay? So how do we address that? I mean, this may come across a little edgy. It's nice here now saying, we're going to be the big bullies on the block, but if the judge dismisses it, what do we do?
Director Wong.
Sure. Well, we are presently, some of the cases that you reference are cases that are charged under theft statutes because, number one, that's what we have available to us now, right? And the reason some of the judges have dismissed that is because they have found that the theft statutes do not apply to the fraudulent conduct in these cases. The reasons for that are contained in this bill, right, that would cover that. You see destroying records after a lawful request. We have cases that we charge where we believe services are not provided. We have some witnesses who say, I didn't get services. We have agencies that keep no records whatsoever, operate out of a mailbox, have no service records, and have destroyed them after we sought to seize them, right? We say that is theft by swindle. Judges have said, your theft by swindle statute doesn't cover that. So we have included a subdivision here that would codify that as medical assistance fraud and allow us to charge that case going forward. We have other instances here, for instance, presenting false information on provider enrollment documents. We have had judges who said that is a crime of theft by swindle. We've had judges who say that is not. There is now a specific subdivision here that says if you present false information on provider enrollment documentation with the intent to defraud the Medicaid program, you are guilty of medical assistance fraud. This should eliminate those rulings from judges that dismiss the cases. In the interim, we appeal those decisions. We are presently appealing one of them. There are others that we have appealed, and we will continue to do that because we do believe that the present laws cover this conduct, but we also recognize that there is a difference of opinion between judges in districts, as happens all the time for district court judges. And so we have chosen not only to appeal that for the current cases, but to write a law that will eliminate these problems in the future for our prosecutors and will allow us to prosecute what seems to be, to any outside observer, clear Medicaid fraud.
Follow-up? Thank you, Chair. Okay, thank you. So, and this is not a gotcha question, okay? But this is what I'm hearing out in the district, because these are taxpayers' dollars, okay? So why do we have a U.S. Attorney General office who has this amount of cases, and what it seems, again, I'm not here to poke your eye, but it's going to come across that way, the Minnesota Attorney General's office is way down in the basement with the amount of cases. This is what we're seeing. This is what I hear from the public. So how does this bill help that? Or why do we have what seems like such a different amount of fraud cases that's being prosecuted, please?
Director Wong.
Or even addressed?
That might be a
Attorney
better question
General
for me.
Ellison.
Yeah, what I would submit to you, Representative, is that this is because certain high-profile cases have received quite a bit of attention, but we are prosecuting Medicaid fraud cases all the time in large numbers. That's just the reality. So if you ask me why does it seem this way? It seems this way because there have been some high-profile cases that are different from Medicaid fraud that have received a lot of immediate attention, as they should. And so it seems that way. But the fact is that our office is very busy and, in fact, needs more people to do the work that we're facing. And given the fact that the current United States Attorney's Office in Minnesota has seen a dramatic number of resignations, we certainly feel that where there is parallel jurisdiction, we really may have to take some of those cases. So that's the reality of it. You know, there are feelings and appearances, but the numbers suggest, or don't suggest, they show that our office is extremely busy and very highly effective. And in addition to that, we work with federal authorities all the time where it's appropriate to do so. So I hope that answers your question, but we'd be happy to respond to any follow-up.
Did you want to add anything, Director Wonka?
No.
Okay, thank you. Thank you. Thank you, Chair. Thank you, Attorney General. So when you talk about the numbers, and again, we are here to work with you guys, because when we're in our district, we get the bulk, and it's not hugs and kisses, okay? Because these people work really hard for their taxpayers' dollars, and they're getting quite ticked off that, you know, we're seeing this. So when you say, well, we have high volume of numbers, and I would not disagree, there are some high profiles, but at the end of the day, it is our responsibility, your responsibility, to be a good steward of taxpayers' dollars, and our constituents are saying, that's a bunch of snert, and so forth. So, I mean, address that there. When you say, well, we're doing high volumes, define high volumes of cases being prosecuted, and then explain also, of course, how it seems that you're saying that this bill would help out because you're going to get more people, too. So if you could, one of you two could answer that.
Well, I'm going to leave the numbers
AG
issue.
Olson.
Thank you, Mr. Chairman. I'm going to let Mr. Wonka deal with the numbers issue. What I will say is that if we all agree that we've got to protect taxpayer dollars, we've got to stop fraud and fight it, then what I'm telling you is that we have been, we are, and we will do more prosecutions. We've convicted over 300 people in the last several years, convicted them, not just charged them. We charged many more than that. And so the answer is not to oppose our bill. The answer is to support our bill so that we can do the prosecutions that your constituents and mine expect. So.
Director Wonka.
Yeah, and just to put a finer point on that, you know, like I think I touched on, you know, we were 6th in investigations per Medicaid expenditures in the entire country last year. We were 5th in fraud charges, and we were 8th in fraud convictions in the entire country. And we've been on average 5th in fraud convictions in the entire country over the last 6 years. In 2023, we had more convictions than all but 5 units, and 4 of them had much larger budgets than us. In 2024, we were 5th in the country in fraud charges. So this is not to say, and this is, keep in mind, this is in the Medicaid fraud space, right? Our federal regulations do not allow us to use Medicaid fraud, the Medicaid Fraud Control Unit, to investigate or prosecute fraud in other program areas. That's not something we can do. The feds will take back money from us if we do that. That's just the way that our grant works. That's the way that our federal regulations work. So when we limit this conversation to the Medicaid fraud space, which is what we're talking about, right? And you've undoubtedly heard about this, the housing cases that are being investigated by the U.S. Attorney's Office, the autism cases that are being investigated. Our investigators work with federal law enforcement authorities to investigate those cases. But when the United States Attorney's Office shows an interest in prosecuting it, that's great. They have much more expansive statutes than we do right now, and we're trying to correct that with the MAP Act here. They have much higher penalties than we do. We're also trying to correct that with the MAP Act here. And they can collect restitution in a more expansive way, which again is one of the reasons why it's here. So when they show an interest in prosecuting these cases, we want to help them. We devote our investigators who have specialized expertise in Medicaid to assist on those cases by helping them with search warrants, by helping them doing interviews in the field, by helping them with the data analysis. And then those cases are prosecuted and people are held accountable. And we do that because it's the right thing to do. But within our regulations, we are also required by federal law, whenever the United States Attorney's Office or federal law enforcement is conducting an investigation into a Medicaid provider, we are required to provide them with any information that we have in our case file and to assist them in that investigation. So that's what we're doing. And that's what we're doing as a state. And if that is not being publicly shared as much as it should, that's something that we can try to do a better job of messaging. But I hear you. I hear your constituents' anger at this. I think that everybody is upset, rightfully so, about the level of fraud. But we at the State Medicaid Fraud Control Unit and our people have been doing this work on the ground and have been getting very good results with the resources that we have for years.
Just final comment. Yeah, thank you. And I appreciate that. I think, I mean, I know we're focusing on the bill and we can go under different sidelines. At the end of the day, though, we have constituents, quite a few of them, who does not think that state government is doing its job. And I would invite you to do it, because what our constituents are seeing is like, and I heard that from you, Attorney General Ellison, is, you know, we've captured $80 million of fraud, okay, in Medicaid. I think that's what your statement is. That's like giving a child a bite of an apple and then running away and giving 5 gallons of ice cream and saying, I'm being a healthy parent. What our constituents are seeing is, well, how about all this? Now, you and I understand that you have certain jurisdiction, but you also have influence too. You know, we all have jurisdictions in what we do, but we also have influence. So it's that perception that's really concerning, because we see the Attorney General office, U.S., seems to be doing more than what you're doing, and you gave an explanation on that. So that's my final comment, because I suspect other people have questions.
Mr. Chair, can I just respond briefly?
Attorney General Ellison.
Let me just say, this communication issue and perception issue, that's something that I think we should take on. I can say before this committee that I have no idea who Mr. Wonka voted for, what political party he's a part of. Don't know, don't care. He is a hardcore prosecutor who prosecutes criminals on behalf of the state of Minnesota. So when it comes to, please don't make it his responsibility to communicate better with the public. I'll take that on. And all of us who have election certificates can do that. But let the prosecutors prosecute. And I just want to be clear if you hear what I'm trying to say. Yeah.
Representative Uganda.
Thank you, Mr. Chair. First of all, I would say I'm on record as supporting this, so I'm in full support of what's happening here. Inside of that, you know, if you have a department that's running pretty nearly at capacity, you kind of do the work, do it well, but you can't maybe go above and beyond. So you're waiting for referrals, and I'm seeing the numbers of referrals going up. But if you get to where you have the capacity, I would think that, you know, the people that you're working with, the fraudsters, the criminals that are there, might be part of a network. You can start to dismantle that network, and you can start to go after some bigger fish. I feel, and then the better teeth to do the better prosecution and have it actually stick, where they actually become sentenced and appropriately. And so we're giving you the teeth, we're giving you the staff, we're giving you the budget. Do you think you'll be able to go above and beyond and actually uncover more fraud, not just wait for the referrals?
If I may, Mr. Chairman. Well, certainly with the tools, if you all can help us get this bill through, I believe that will happen. But I do want to offer this very important caveat. So the way this system is set up is that there are people who work at the agency and they screen who gets in, who doesn't. We have zero to do with that. Then there's the ongoing monitor of people participating in the program. We don't have anything to do with that. Then people at the agency level think, okay, this doesn't look right. Then we get it. Then we're on. We get there basically when the 911 call is made, just like the ordinary police and prosecutors. Now, how can I say yes to your question? Here's how. Because once Nick and his investigative team start digging into stuff, it's like, oh, wait a minute. This person showed up here and here and here. What's going on there? Now we're starting to unravel networks. And so I want to say, the answer to your question is yes, we can. Yes, we will. Yes, we will be able to do that much more effectively, but not necessarily through the normal channel. Thank you very much.
Thank you. Representative Murphy.
Thank you, Mr. Chair. Thank you. My question is really around, you know, we have this need for holding wrongdoers accountable, and I appreciate that we're looking at some of those same things. My question is that we've had a lot of whistleblowers that have come forward. What is your record? What have we done in terms of the number of whistleblowers that have reported issues within the agency of the DHS as far as disciplinary actions, how many? With regard to under investigation, how many? With regard to prosecutions, how many? You know, you're looking for a lot of dollars, $800,000 to increase your activity. What's the activity been to date with regard to DHS, not including feeding our children?
Mr. Chairman,
A.J. Ellison.
Representative, we don't have anything to do with the operation of the agency. The agency, we're a separate entity set up by the Minnesota Constitution, and we operate in the role of prosecutor and investigator. So let me just say one more time, when people apply to be in the program, they deal with an agency. Then when they engage in the activity of the program, they're monitored by the agency. When there appears to the agency there to be criminal conduct, they refer to us. So to the degree that somebody, so the whistleblowers, look, if we believe somebody violated the whistleblower statute and we have authority to prosecute it, we certainly would, but that's just not our lane, if you understand what I'm trying to say. You know, our lane is like, think of the show Law and Order. We're that. We work with the cops and the prosecutors. That's who we are. We don't run the agency. So, I mean, I don't know, do you want to add anything?
Director Wonkum.
Yes, I would just add, there's federal regulations that require us to be entirely separate from the agency that administers the Medicaid program. So if a tip comes to us and is directly reported to us by someone, that's going to go through our normal intake process that we do with any sort of law enforcement tip, formal referral. If there is a whistleblower who reports internally to other people at DHS, that is not automatically going to come to us. We're not even going to be aware of that. And we certainly don't have any sort of disciplinary authority or anything like that over DHS employees. Does that answer your question?
I just have a
Representative
follow-up.
Murphy.
Thank you. So if there is a whistleblower and it does come to the level of a criminal activity, when and who gets involved in? Are you involved if there's a criminal activity inside of DHS?
Mr. Chairman.
A.J. Ellison.
So, Representative, if, say, for example, hypothetically, there's some sort of criminal wrongdoing happening in the agency, and a whistleblower says that's wrong, and say theoretically, hypothetically, they call our office. What I would do with that is and it probably might come to somebody else other than me, but say it comes to me. Say, hey, boss, guess what happened? What I would do is I would contact the county attorney's office or the U.S. attorney's office or the FBI or the sheriff or the police. And the reason why is that representatives and senators in years gone by wrote the statutes of the state of Minnesota, which empower county attorneys to prosecute crime in the jurisdictions in which it happens. Let me be clear, and this is important, because I didn't know this when I got this job, so I don't expect people to just know it. But the only cases that we have original jurisdiction on, the only case that I don't need to talk to anybody to charge as a crime are Medicaid fraud cases. Every other kind of fraud case is the county attorney or the U.S. attorney. Now, Medicaid fraud is a specialized thing because we get a federal match, 1 to 3, and then there are clear program guidelines as to how we operate that program. So because what you're sharing, the situation you're sharing is a real situation, and I share your concern about it, we want whistleblowers to be protected and to come forward. But if this ever were to come my way, I'm going to be calling an investigative agency or the county attorney.
Representative Murphy.
So if we call the county attorney and there's a criminal activity in the DHS, so I come from agriculture. The barn door is left open. Cows got out. Rustlers stole the cows. Is the guy that left the barn door open have any responsibility? And if he did it on purpose, can the county sue that individual that the whistleblower brought forward?
AG Ellison, I know we're deviating
Yeah,
from
yeah,
the discussion of the bill.
thank you for your question. It's an important question. But it's a little out of my lane and what we're doing here. But just to answer your question, it would depend on whether it was negligently left open, deliberately left open. Maybe the guy was in on it and he said, hey, I'm gonna just leave the door open and you come back. Then that would be a crime and they would have to face responsibility, criminal liability. If it were a negligent act, maybe there would be civil liability for it. If it were an inadvertent act that there was no culpability for, just pure accident, not that, no one's fault, then maybe it wouldn't be charged. But it would depend upon what we call in the legal world mens rea, which is your mental state when you did what you did.
Just the last comment.
Representative Murphy.
So, thank you, Chair Nor. So just as a kind of a 30,000-foot view, though, the AG's office and the folks that we're talking about here, if there are people that are criminal, have done criminal activities and leaving the barn door open, that's not something you would be able to prosecute.
Attorney General Ellison or Director Wonk?
It would depend. I can't get, this is a very fact-specific question, right? What you're talking about is really either a conspiracy between DHS employees and providers who are stealing from the program, or it rises to a level of what we would call aiding and abetting under the law, where DHS, your agency employee is aiding and abetting provider fraud. And what the law provides there is you have to prove beyond a reasonable doubt that the employee knew the crime was being committed and intentionally aided the crime. If there is evidence of that, and it is aiding and abetting provider fraud, that is theoretically something that could come within our jurisdiction. That's true at DHS, that's true for a managed care organization. But again, that is a very specific, fact-specific inquiry that would depend on what was uncovered in an investigation. Does that answer your question?
Yeah, thank you, Mr. Chair.
Thank you so much. We have Representative Knudsen.
Thank you, Chair. Thank you for being here today. Just have a couple questions. First, what is the most recent budget for the AG's office?
AG Ellison.
Yeah, you know, I came here to talk about Medicaid fraud. If I came here to talk about budget, I'm sure I'd have to the penny numbers, but just didn't. I came here to talk about this program and this bill, ma'am. I'm sorry.
Representative Knudsen.
Okay. Thank you, Chair. I'm sure we can probably find that.
Yeah, it'll be easy to find.
Yep. And how much of this budget goes toward the Medicaid fraud unit? Do you have a percentage, a ballpark?
Right.
AG Ellison.
So we put up. The state of Minnesota provides a quarter of the Medicaid fraud budget for our Medicaid fraud control units. So it is certainly a substantial amount of money, but it's relatively small compared to our overall budget.
Representative Knudsen.
Thank you, Chair. So the rest of that's a quarter, is the rest of that federal?
Yes.
AG Ellison. Representative Knudsen.
Thank you. Thank you, Chair. How many prosecutors do you currently have?
Director Wonk.
So we have 32 people on staff right now. There are 7 prosecutors, 17 investigators, and the remainder is legal support staff, legal assistants, paralegals.
Representative Knudsen.
Okay, thank you, Chair. So you have 7 prosecutors right now?
Yes.
So with this $800,000, how many more prosecutors are you going to be able to hire?
Yes,
Director Wong.
this will be 3 prosecutors, 11 investigators, and 4 support staff. And the reason for that is right now our greatest need is for people who can get on the ground and go out and knock on doors of providers, ask questions of providers and recipients who we think are either not delivering services or not delivering what we want, who can review healthcare records, who can execute search warrants, do that data analysis to move this bulk of cases into the charging stage.
Representative Knudsen.
Thank you, Chair. Just one more real quick. So there is no room in your current budget to do this without more money.
A.J. Ellison.
So, under statutory guidelines, we cannot just shuffle money around. This is a specific federal program that requires a match, that requires that we don't have people who are working in other parts of the organization coming over to the Medicaid control unit. And it's all, and not only does the grant require us to operate that way, the skill challenge does too. So for example, we have a group of criminal prosecutors at the AG's office who do general crime prosecution. But this particular unit requires you to know a lot about, first of all, the Medicaid statutes, and then also how to use complex white-collar fraud documents in your prosecution, how to investigate them, how to present them to a jury. It's just not something you can have somebody come from charities and just do. It would take them 6 months to be able to do the work. So we can't just, so it's a very caverned off group. So I don't know, Nick, do you want to elaborate?
Director Wong.
Yeah, so this funding source, right? Our grant and the federal regulations surrounding it require anybody in the Medicaid fraud unit to spend 100% of their time working on investigation and prosecution of provider fraud or the abuse, neglect, and financial exploitation of vulnerable adults. We can't have somebody who, say, spends half of their time in another division and half of their time in the Medicaid fraud unit, because that's going to violate the federal funding requirements in what's called federal financial participation for the unit.
Representative Knudsen.
Thank you, Chair. And just final, I wasn't suggesting that you use people from other agencies or anything like that. I was suggesting that you find the funding from your already very large budget. So, thank you.
Vice Chair.
Thank you, Chair. Thank you, Representative Norris, for doing this work. I know that you have been really diligent in finding us good solutions across the board around this. My question comes from the penalties part of this. I know you guys mentioned that penalties are much higher if fraudsters participate in fraud against the private entities. The changes that we're making here, I know that in the amendment, they're on 229 to 3.5. With those changes, where are we in comparison to the private market penalties? Are we consistent? Would this be higher then? Could you explain that to us, please?
Director Wong.
Yes. The 20-year maximum for the over 100,000 is the equivalent with the current theft statutes. So right now, what you see in a theft statute, a theft by swindle statute, that's the maximum penalty. The 30-year penalty for over $1 million, that does not exist in the current theft statutes. That is in the Medicaid assistance fraud statute. That is a new level based on just exactly how much fraud we are seeing in the program. It is also being done because if you look back at the current theft statutes and the $100,000 limits, those were put into place in the late 80s. They have not been updated in amounts for over 40 years. And stealing $100,000 in the late 80s was a lot different than stealing $100,000 in 2026. So having a new statutory level for large dollar offenses against the Medicaid program is why that over $1 million penalty is in there.
Vice Chair.
Thanks, Chair. I'm really appreciating your deep answers. I think I just need a little bit more simplified answer. If I am a fraudster and I look at the penalties, is what we're changing making government penalties comparable to where the private industry penalties are? Or are the penalties that we still have with these changes for a fraudster coming to take money from the government, where are we in comparison to that?
Director Wong.
If you stole money from the Medicaid program, you would be punished now, under these changes. If you stole $150,000 from the Medicaid program, it would carry the same penalty as if you stole it from the private sector if you enact these amendments.
Thank you. Thanks, Chair.
Thank you so much. A.J. Ellison, closing remarks.
I just want to say thank you, members, for your kind attention to this issue. I would like to speak to everybody individually about the importance of supporting this bill. I want to thank all members. This is a good bill. It's an appropriate bill for the moment that we're in, and thank you for your kind attention.
Representative Norris, your final remarks?
Yeah, thank you, Chair Noor, and thanks to the committee for the discussion. I think, this highlights the fact that, there's not one silver bullet that's going to solve all of the fraud challenges that we're seeing in Minnesota. It's going to take multiple approaches, in part because there's lots of different players in the system, and each of them have a unique role to play. The Medicaid Fraud Control Unit has a critical role in that, and I think it's clear that there's a need to enhance the penalties, give them more tools in the toolbox, expand the definition of Medicaid fraud. And I'll just highlight for the members, since I think this is in your packet, kind of to the point of the effectiveness of this office. On the last page of the handout, these numbers are from the federal government. So they're, unbiased source from the federal government. You can kind of see the number of staff that our office has compared to similarly sized states in terms of Medicaid budget. And then it also notes that an audit from the federal government found that from 2020 to 2022, Minnesota won the most convictions for provider fraud when compared with similarly sized states. So despite having half to a third of the staff that a lot of these other similarly sized states have, we were able to win the most convictions compared to those states. So I think that's something Minnesotans can take confidence in, and by giving them more tools, we can do a better job of cracking down on this business model of fraud that we're seeing across Minnesota.
Thank you so much, Representative Norris. I know we have a few things that we wanted just to update, like the PCA mentioned. We wanted to add the new term that we have for the PCA, CFSS, just to make sure that it's more clarity. I don't know. We will do that in the next, it's just more of a technical as we move forward. With that, Representative Norris renews his motion that House File 2354 as amended to be re-referred to Judiciary, Finance, and Civil Law. All those in favor, please say aye.
Aye.
Opposed? The motion prevails, and the bill as amended is now re-referred to Judiciary, Finance, and Civil Law. Thank you so much, everyone.